Hi, I'm Kevin Walton. I'm with C2 Reverse, and I do reverse mortgages only in California. Today I'm going to make a video on how things work when the last borrower, possibly your parent, on a reverse mortgage passes away. This is version 2025. So what do you do as an heir? When do you do it? How do you do it? What does a lender do? Are they going to foreclose? How do I work with them? I'll cover those topics. Now, as far as also another idea, how to keep the property in the family if the balance on the loan is greater than the value of the home, there's still a way you can keep the property in the family, and I'm going to give you an idea on how to do that. So keep tuned here, and if you like what you hear, please hit the subscribe and like button so other people can find this video. So some quick facts here before we get into the meat of the presentation. Keep in constant communication with the lender. Very important. They don't know what you're doing. You don't know what they are doing. They have a clock, a timetable that they have to follow for this process. It's important you understand how that works, which we'll get into in a minute. Also, don't try to remodel the property. And I'll get more into that, but I just thought I'd mention that up front. I divide this video up into chapters, so you go and scroll down at the bottom. If you don't hear the information you want to hear immediately when you're listening, skip ahead to some of the other chapters. There's some nuggets there that you'll need to know and probably will help you out. Okay, first few things here. If you have two parents and they're both in the property and both on the loan, if one of them passes away and the other one's still in the home, nothing changes. It resumes. You don't have to do a thing. If one of the parents is in a facility where they're convalescing and the other parent passes away in the home, if the home is vacant for 12 consecutive months, then the loan has to be paid off or the property gets sold. Now, if the convalescing parent comes home for a month or so in between surgeries, that restarts the clock at another 12 months. It isn't 6 months, as some people have said. For health reasons, if they're out for 12 consecutive months, that's when that kicks in. Non-borrowing spouses. That is a spouse, let's say someone gets a loan, HECM reverse mortgage, and they're 7 years old, and their spouse is 55. Well, they're not of age to get a HECM reverse mortgage because the minimum age there is 62. So they can't go on the loan. But the lender knows that they are there at the time of the loan process. If the older spouse passes away, even if the younger spouse didn't go on the loan, they can still stay in the property. They just don't get access to any money. So if there's a line of credit available, they won't be able to access it when the older spouse passes away. That's what a HECM, federal FHA reverse mortgage. There's other reverse mortgages out there that are not HECMs. They're non-HECM mortgages. Those have a different set of rules. If there's a non-borrowing spouse there that didn't go on the loan, then they don't get to stay in the property. They then have to have the loan paid off or the property sold. So it's really important you know what type of reverse mortgage that you have when it comes to this non-borrowing spouse rules when a parent passes away. All other occupants, if your parents pass away and there's other people living in the property, if they aren't non-borrowing spouses, then they don't get to stay in the property. The property must get sold or the loan gets paid off. They don't get to keep the property and rent it out, the people who are not on the loan. So that can be an issue with reverse mortgages. If you are taking care of your parent and they pass away, if you're not on that loan, and you can be on the loan. If you're 60 and you're 60, at least 62, you can be on the loan with your parents at the time they take the loan out. It's got to be at the time to take it out. But if you're not, if they pass away, then you do have to vacate the property. So that can be a problem with a reverse mortgage, and you just need to know that. Okay, so this is how the process starts. You have to notify the lender upon the passing of the last borrower in the property. You have 30 days to notify the lender. Then the lender at that point, once they're notified, they send to the property a demand with things that have to happen. and they'll send the demand to not only the property, but other people they have that might be alternative contacts. Doesn't always mean the letter goes out, though. So you just have to know that a demand letter will go out. That starts the lender clock ticking, because the lender, if they don't follow a certain timeline on a HECM, federal reverse mortgage, they get fined $15,000 per loan. So that's why they're pretty aggressive when it comes to this clock, that they really push things along. So they will give you 30 to 45 days from the date of that demand letter to let them know of your intentions. So you got to say, I'm going to sell the property, or I want to retain the property and try to get a loan to pay off the reverse mortgage. Or maybe the property's upside down and you don't want to keep it. You could say, I'm going to give you a deed in lieu of foreclosure, which means that you just sign the property back over to the lender. So those are options there, but you have to let them know after that demand letter, 30 to 45 days from there, what your intentions are. So now you're about 45 to 60 days into the process. So if you haven't let the lender know within 90 days what your intentions are, they're going to start the foreclosure process. Once they refer the file to the legal department, all of a sudden you got attorney's fees that pop on there, and they get added to the balance. It's at least $5,000 to $10,000 just to add legal fees to the loan in the beginning. And as the process goes along, it could and will be more. So you need to be aware of that. So at the latest, 6 months after the borrower's death, the lender starts the foreclosure process. But you say, wait a minute, you just said I have like 30, 45 days. Well, sometimes if there are arrangements made and there's maybe legal action that starts getting involved, the lender might pause. It doesn't stop the timetable, though. It just means they give a little bit of extra time. But at the very, very latest, regardless of the situation, 6 months after the borrower's last, the date of death, they will start foreclosure proceedings at the very latest. In some states, it's earlier, because if there is a living trust on the property, they may start foreclosure a little bit later. If there's not a living trust, they'll start earlier, because the probate process can take a long time. So if the lender is foreclosing on a property with a reverse mortgage and there's nobody who passed away, but they're foreclosing because maybe lack of property tax payments, something like that, they will use, since there's no date of death to start the clock, they will use what they call a due and payable clause. They'll call the loan due. And that date, when they call the loan due, will be part of the timeline process in lieu of a date of death. So again, once the lender attorney touches that loan, you've got foreclosure fees that start to rack up. And the interest on the loan doesn't stop either. It will keep accruing as well. So the lender, after you've given them your intention, let's say you're going to sell the property, they will give you a 90-day extension to give you time to sell the property. And if you still haven't sold it in 90 days, they may give you another 90-day extension. Now you're 9 to 10 months, maybe 9 months into the process when you get that second extension. But they're not just going to give it to you automatically. So if you hear someone says, oh yeah, you get 12 months after your parent passes away to sell the property, that's not an automatic thing. You have to be actively marketing the property. If you have family members who are bickering it, maybe one family member says, hey, let's rent it out. And the other one says, no, I want to buy it. The other one says, no, I want to sell it. And if it's just kind of vacillating and not really moving forward, the lender will not extend the additional extensions, and they'll just move forward and foreclose. So your intentions have to be clear. Everybody has to agree, everybody being the heirs. And you have to follow through with your intent. If you change it from selling the home to wanting to pay off the loan at the last minute, they're not going to necessarily give you another extension. So you have to be aware of that, because again, they do have that timeline, that clock that they have to follow. Otherwise, they get fined $15,000. So again, don't try to remodel that property. If you do tell the lender that you're going to remodel the property, they're not going to give you any extensions. No first 60-day, 90-day extension, no second-day extension, because sometimes the lender ends up owning the property with a half-finished remodel, and then they got to pump money into the remodel to fix it and complete it, and then list the property. So they're not a big fan of remodeling. If you do that, it's got to be done quick, and maybe without mentioning it to the lender. But you just have to be aware of that factor. So there are three main ways, that properties are held after death. It's either there's a living trust where the property's inside of that. A living trust was created by the parents. There's probate, which is if you don't have a living trust, if you don't have an estate plan, the state has one for you, and that's called a probate. And then there's a will or living testament. Depends on what state you live in, they call them different things. A will also have to go through the probate cycle. Now, probate can take a while to clear, and it's real important that you know how the property is held. If the lender says, well, we need a copy of the trust, and your trust attorney says, you don't have to give it to them, it's none of their business, you need to give it to them, because what happens is that as you delay getting the trust document to them to show that you are an heir and you have ties to this property, if you don't give it to them, it starts eating into that clock. At the very end of the process, it will cut your process shorter and give you less time to get things done. So that would be an important thing to find out if the property's in trust, or if it's going to have to go through probate, or if there's a will. So let's say you're contemplating as an heir to help your parents with their estate. A living trust is something really to consider, because in California, where I reside, just a simple probate with an estate that does not have a living trust, the administrative costs are anywhere between $20,000 and $40,000, and they could take up to a year or more to conclude. So it's not an inexpensive process. It's a very lengthy conclusion process. And that's just for a simple property, owning one property, a couple cars with some assets, retirement accounts. But if you have a business, a corporation that your parents are a part of, multiple properties, that probate can be much lengthier and much more expensive. So having a trust is critical, in my opinion, because to create one, it costs maybe $1,500 to $3,500, depending on the complexity of the estate. And just by creating the trust, it will move smoothly through the transition process after the last living borrower passes away, because it doesn't have to go through the probate process. So once a lender is in foreclosure on the property, and you're saying, why are you going into foreclosure? I'm telling you what I'm going to do. A lot of people don't follow through, or legal maneuverings by the parties derail the process. So a lender just starts foreclosing, and if you get your process done, probate, living trust done, then they'll pull the foreclosure and they'll allow the sale of the property to happen. But don't be surprised if they start pushing forward with foreclosure early on. And then again, you've got the probate fees, $20,000 to $40,000. You got the legal fees for the lender, $5,000 to $10,000 and more. So you've got fees, and that all takes away from the equity of the property when it's sold, or it gets taken from the estate. So there's ways to cut those costs, and having a trust in place can really help. Now, as I mentioned, probate can take up to a year to conclude. Living trust can conclude in 30 to 90 days. Transition is much smoother to the heirs. The lender will not wait for probate to conclude. People think, well, the lender can't do anything because they have to wait until the probate courts are done doing their thing. No, they don't wait. They will keep the foreclosure process going. They can get a property back during that probate process. You could lose it, the property. So you can instruct the probate court to sell the property while you're going through the probate process, And then the proceeds from the sale of the property will stay in suspense, and then they'll pay the lender after probate concludes, or maybe they'll pay them earlier. It really depends on the situation and the state that you're in. But you don't want to go through that probate process. Have the trust in place, and you can avoid probate, and you'll have more than enough time to get this whole process figured out and executed without having to worry about all of the court costs and the lender being impatient. A trust will really help that process. He just reminds you, hit that like and subscribe button, because this information, these nuggets, they're hard to find online. And people need this information, because I get calls all the time for people wondering how it works when they're right in the middle, in the throes of this stressful situation. So again, no automatic 12 months to sell the property like people will tell you. It's not automatic. The non-HECM reverse mortgages, again, I want to remind everybody, not all reverse mortgages are the same. They don't have the same guidelines, the same rules. Some are 55 and over, some are 62 and over. Not all reverse mortgages are available in all states. So there are different rules, different state-specific rules. So you have to ask a lot of questions to the lender. And then getting those 90-day extensions on the HECM, FHA version reverse mortgage, not automatic. You've got to show your intent and have a plan in order to get those 90-day extensions and be actively going through with those intentions. Okay, I mentioned at the beginning of the video that I would give you a tip, an idea on how to retain your parents' property if they owe more on the loan than what the home is worth. Really important, on a reverse mortgage HECM, there is insurance on that loan. MIP, Mortgage Insurance Protection. They had to take out this insurance when they took out the loan. It's required. That's one of the most expensive parts about getting a HECM reverse mortgage, is the upfront insurance. This is where it comes into play. If you owe $400,000 on a property that's worth $300,000, and you're like, they owe more than what it's worth, there's no equity in it, let's just give it back to the bank. There is gap insurance that pays that gap. You're not responsible for that deficiency, neither are your parents. So the insurance pays that gap. So the lender, after they've been notified by you of the death of your parent, the last living person in the property, they come out and they do an after-death appraisal. And that number is really important, because let's say you want to keep that property in the family. Say, you know what, I grew up there, we'd love to keep it. And, you know, my sister, she lives in town, she'd love to live there. There's a clause when the property's upside down, only when you owe more than what it's worth. You can purchase the property for 95% of the after-death appraisal. So if the property's worth, they appraise it for $400,000, you can buy it for 5% discount, which is make the property $380,000. That's what you can get the property for. And you say, wait a minute, they owed $500,000 on it. Why would the bank do that? Well, the insurance pays the gap between $400,000 or $500,000. They owed $100,000 more what it was worth. And then you can get 5% off of that after death appraisal? Yes. But you won't get it if you don't ask for it. Couple real important things, caveats that go with this. Now, you have to get your own loan to pay off the reverse mortgage, that 95% figure. You can also, if you are of age and there's enough equity in the property, get your own reverse mortgage to pay off your parents' reverse mortgage, assuming there's enough equity in there to do that. That's possible. Otherwise, you go out and get a loan to pay off the reverse mortgage for that 95% figure. Now, you cannot go on title to that property. A lot of parents will say, well, let's bring the kids on title after we get the loan, you know, just because that's what people used to do. Don't do that. Because now you don't have the opportunity to take advantage of this 95% rule. You can only come on title after your parent or parents pass away. That will set you up for this 95% rule. So really important you know those steps, and you have to do them in the right order. If you have intentions on taking advantage of that 95% after death appraised amount to keep the property, you have to let the lender know up front that's what you want to do. Otherwise, they're thinking you're selling it, you're going to go out and get a regular loan and pay it off. Because there's certain criteria that they have to do on their end for this 95% figure to be valid. They have to check boxes in a certain order. So again, to come on title to the property after your parents pass, the best way to do that, have in the will the living trust, preferably language in there, specific language that mentions you by name, that you can come on title after they pass away. You can't just come on title after your parents pass. You have no authority to do so. But if you have a living trust from your parents that specifies the heirs, and if there are 3 children, Johnny, Jack, John, Johnny has first right to come on the property after I pass, because Jack and John already have properties. Be nice if the other son can have the property. So there has to be very specific. Who can come on title first? Who has a second chance to go on title? Who has a third chance to go on title? After their passing. Has to be after they pass. Put that language in the trust, and that will give you authority to have that happen. And the lender will see it as well because it's in the trust. So that's the way to kind of structure this. Because if you don't do things in the right order, they're not going to permit it. So, okay, that 95% rule is unique, and it's only on HECM reverse mortgages, not non-HECM reverse mortgages. It's not available on those. So again, notify the lender of your intentions up front before you get added to title. The lender will dictate if the transaction, if that's what you're going to do, if it's going to be a purchase or a refinance. If you're already on title, they won't permit it. But if you're already on title after, and the trust says you can come on title, you can't buy the house from yourself if you're on title. That would be a refinance. But the lender may have a special order and a special transaction that they have to do on their end for you to take advantage of that option. And again, you would obtain your own financing to do that. If you decide, you know what, I live out of state, the property's just too much to take care of, they owe more than what it's worth, I don't want to do that whole 95% thing, because that's for owner-occupied only, the 95% rule. It can't be for a property you're going to rent out. No lender will give you a rental income property loan with 5% down payment, 5% equity. You generally have to have at least 10 to 20% equity in those properties, those types of loans to get those properties. You can do a deed in lieu of foreclosure. That's where you just sign a paper, the lender sends it to you, and it just goes back to the bank. That way, you wipe your hands of it, the bank will go ahead and market the property and sell it. The property needs to be in a bedroom swept condition. It can't just be leaving junk in there and have it, a lot of things scattered out in the backyard. Broom swept condition for a deed in lieu of foreclosure. Okay, just to wrap things up here, hopefully this information has been valuable to you. Property taxes, homeowner insurance, and other charges like, homeowner association dues, those have to be kept current by you. They cannot add those to the balance of the loan. On FHA reverse mortgages, they can't add anything to the loan. If the property is going through probate, their delinquent taxes, those will get collected. If you're keeping the property or even selling the property and there's equity left, the taxes will get paid. insurance, delinquent HOAs, legal fees to the lender, realtor fees, and probate fees. Fees. And that could just take away a huge chunk or all of the equity. And then if there's still money's owed, they'll take the rest from the estate, the cash that's available to you as an inheritance from the estate or investments. So you want to try to keep those fees at a minimum. A trust will help having a plan up front, knowing what you're going to do, buy the house, take the 95% rule, opportunity, deed in lieu of foreclosure, or sell the house. You got to know your plans going in. You can't be added, again, the fees can't be added to the balance on these reverse mortgages. They can be taken out of the estate. The interest never stops on a reverse mortgage. It just keeps calculating. So it doesn't stop. Now, if you get a 90-day extension to sell the property, they may stop legal fees at that point, but not interest. It pretty much never stops. So know those things going in, know it up front, to try to keep your losses, if any, at a minimum. So there you have it. That's the information on how to handle the situation when the last borrower passes away, maybe being your parent, how to work with the lender, what to say, what not to say, know how the lender has to do their process and their end to avoid that $15,000 fine, and keep communication lines open with that lender. So important. If you do like the content of this video and you found it useful, please hit that like and subscribe button. That way other people can find it. And if you need any other help or questions, my contact information is in the description below. Thanks again, and I'll catch you in the next one.